Good afternoon and welcome to the Appellate Division, First Department. We have 6 hours of requested argument time, so I'm going to ask that you request the time you need, not the time that you want, understanding we are fully familiar with your briefs and the record, usually more than you wish we were. And please know that the clock is for you, not for the court. So if my colleagues have additional questions, because your argument is so brilliant, I allow the questions to continue. Okay? All right. People versus Alfredo Colon. Submit. Milchin versus Milchin. Okay? Let's do 4 and 1 and 5. Ildefonso versus Ildefonso is a submit. Sapini versus Ferrara. 2 minutes? Okay. 2 and 2. All right, thank you. People versus Antonio Martinez? Submit. Nation Star Mortgage versus Vasi. Okay. Okay, 3 minutes. Hague versus T&S Interiors Corp. Submitted. Charlene versus Giovanni. Submitted.
Prairie Gold.
Sorry?
Prairie Gold.
Oh, I'm sorry. Prairie Gold, Solar versus AGCS Marine Insurance. I'm sorry about that. Okay. Okay, let's do 8 and 2 and 10. And like I said, you just, if you are brilliant, you're gonna get more questions, so don't worry about it, okay? All right. All right, I did Charlene already. People versus Trayvon Small. Okay. 7 and 2 and 7. And sir, is Trayvon with an A or an E? An E, thank you. Barron's Media versus Shapiro Legal. Okay. Okay, let's do 6 and 1 and 7. Yagual versus Hudson Canal. I'm sorry if I mangled the name. Okay. How much? 4. Okay. 5 and 1 and 4. People versus Steven Hernandez. Submit. Castillo versus Big Van.
Good afternoon, Your Honor. Appellate request 3 and 1, please.
Okay. 3 and 1 and 4. That was less than I thought, a lot less than I thought you, but I suspect the questions will keep you up here longer. Bolek Gowen versus White Plains Kensington. Good afternoon. Okay. 5 and 2 and 3. People versus Robert Lewis. That's a submit. Vargas versus Mavino Realty is a submit. First case argued on the calendar, Milchin versus Milchin. You may proceed.
Good afternoon, Your Honors. Brian Goldstein for the appellant, Richard Milchin. May it please the court. This case is not just about counsel fees.
Counsel, I'm not sure what you mean by that. What we got is about counsel fees, and what I see is that the application for attorney's fees failed to comply with 22 NYCRR 202.16K2, which requires a statement of net worth or a comparable statement. There was nothing like that in the father's papers. So it seems to me that the court was well within its rights to deny the application for attorney's fees in the absence of any statement as to the husband's finances. Father, sorry.
We requested fees under two different statutes and one court rule, as Your Honor is aware, DRL 237, 238, and for frivolousness under NYCRR 130-1.1. The only of those that requires a statement of net worth is DRL 237, which
But
this
that's
court-
for a pending case, and this was a post-judgment case.
Right, Your Honor.
So it's not applicable, so move on.
Well, we also asked with respect to 238, which does apply to enforcement and modification proceedings. And as the lower court indicated in its order, 238 does not require a statement of net worth. The court stated on the record multiple times his familiarity with the parties and the one-sidedness of the ability to pay
Familiarity
counsel.
with the parties is not the same as a contemporary statement as to the father's finances. And why should he be awarded attorney's fees if there's no showing of what the finances are of these parties?
Especially where the application had been previously denied for the same reason. So that you were on notice that the court felt that that was missing in the application, and you continue to make the same application and not cure the lack of a statement of net worth.
The three motions were decided at the same time, and this court has dispensed with that requirement given the substantial lack of merit on the other side. And in this case, the plaintiff herself was found not to be credible. Her witnesses were found not to be credible. The fees for the AFC were reallocated for those purposes. So the judge did recognize that there was a
That
merit.
dispensed with that issue, but that didn't determine that he was entitled to a larger award of attorney's fees. So in a sense, the judge, by reallocating the fees as to the AFC, addressed the issue he was concerned about.
The judge specifically stated on the record multiple times that he's familiar with these parties' finances.
Right, and therefore, he took the action he did, which was deny attorney's fees to your client. If your client thought he was unfamiliar with them, he could have provided a statement of net worth. And
With respect to the statement of net worth, however, the substantial lack of merit to the claims asserted by plaintiff, which were filed in her moving papers, then tried at court, and
Counsel, the court found, quote, excessive and unnecessary divorce litigation on both sides, and it jumps off the record to me. So why don't we defer to the court's determination, which is a deferential standard?
well, there was a case by this court where that was also dispensed with because they looked into the financial need by saying that even though both parties may have contributed to the litigation, which here I believe is different because the mother contributed significantly more by asserting all these meritless claims, but by both parties, this court upheld a $162,500 fee award, even though both parties were labeled as, I believe the word was intransient, which we don't have here.
Thank you. You'll have time on rebuttal. You have 5 minutes.
Thank you. And I'm going to be brief, and I'm going to respond just to a few of my colleagues' arguments. First of all, he says that under 238, you don't need a statement of net worth. That is not true. It is only in an enforcement proceeding under 238 you don't need a net worth statement. There was no enforcement proceeding here. It was a modification proceeding brought by both parties, so a net worth statement was still required under 22 New York CRR 202.16K. I wanted to note that. The other thing is he repeatedly said my client's meritless claims. As the judge noted in his decision, everything that my client asked for, she received at the end of this case. How can that be a meritless claims?
Well, the court also reallocated the cost of the AFC 90% to your client because she had allegedly coached, or the court found, she had coached the children.
And the multiple ACS investigations and the police calls and reports?
Well, as the record reveals, there were multiple police calls by both parties. I want to remind this court, my client had a 2-year order of protection against the father. Generally speaking, when there are orders of protection and things like that, police are called, mainly because of his conduct towards her, showing up in her.
Sometimes when people have orders of protection, they use the order of protection as a sword instead of a shield.
And when they do that, it's the most unfortunate thing because it cheapens all the people who need them. And I didn't mean to interrupt you, Your Honor, please.
Go ahead. 'Cause
And
what
I
you
want to
wanna
say that
is
I
more
find that
important.
conduct despicable, but there's no evidence in this record that my client did anything like that. Okay, if you were to see the trial transcript from the order of protection hearing where the father wrote to her that your mother who had died of cancer would be ashamed of you. I'm going to burn your father's house down. That is not someone who is misusing the system. That is someone who is using the system appropriately. But again, I want to go back to the fact that there were, in many custody cases, I have never seen in my 25 years of practice a parent who was perfect, who hasn't made mistakes. And the court was very clear. Both of these parents have made mistakes, but at the end of the day, a fee application is an exception to the general rule in this state that we don't award fees to the other side. And when you want that fee application, there is a very specific procedure you must follow, and the father chose not to do that. Again, not once and not twice, but 3 times. And this court must assume that there's a reason, and that is that he's not the non-moneyed spouse in this case. And 237 and 238 are for the non-moneyed party. But when you give up your opportunity to prove that, then you can't come to this court and say, why didn't I get it? It's because there was step-by-step procedure that you didn't follow. And again, with respect to sanctions, and I'm going to end there, my client received all of the relief that she sought. And it's in the record. After the court issued its interim decision, there was a neuropsych evaluation of these children that was completed, and it was found that they were suffering from post-traumatic stress disorder, and it was found that their relationship with the father had significant impairments.
Counsel,
Let's not go there.
I suggest that you quit while you're ahead.
Yes,
Okay?
please.
Because you are conveniently forgetting to mention how these children got on the elevator and sat in front of the ACF worker. We lied. We lied to the judge. So please.
And every time an ACS investigation is called, children are pulled out of schools and homes and are questioned. And then they become unsubstantiated because of such contentious divorces.
I'm going to sit down based on what everybody just said. Thank you.
Thank you. You have a minute, sir.
Your Honor, I just want to say very quickly that this is the 4th time that these allegations are being brought. It's the same thing as before the trial that we had. They filed a motion, had
Look,
a trial on
you know,
those.
the thing is, as I hear you, and I see your passion, right? And I read a disturbing record, okay? The problem is, 3 times the judge says there's no net worth statement. So if your client is indeed the non-moneyed spouse, put up or shut up. Show us the net worth statement, give the judge what the judge needs in order to make an informed decision, okay? Because I don't think the arguments and the statements you're making are all meritless, okay? But we are bound by the law.
The decision that the lower court issued was as to 3 motions at once.
I understand.
The fee
But
application kept
each
getting
motion was submitted without what was required. And this isn't like, you know, new law. This is like basic, okay? So I hope you're hearing what I'm saying.
Thank you, Your Honor.
Okay. Sapini versus Ferrara.
Good afternoon.
Good afternoon.
Your Honors, this dismissal was an abuse of discretion. The failure to plead the presentation requirement was just a technical defect, not jurisdictional, and with months left on the statute of limitations, and the defendant saying they don't want to settle with us because the client was still treating, there was no reason not to allow us to amend the
Are
complaint.
you saying that the 30-day presentment requirement is optional?
In this particular case, because when we contacted the insurance company for the defendant, they said they don't want to settle. So
The insurance company doesn't decide what the law is.
I understand.
Sometimes people get confused about that, but that's not up to insurance companies. The requirement is that you make a presentment notice before you file suit against Metro North, and you didn't do that. And I don't see how any conversation with the insurance company could relieve you of that obligation.
The only argument we're making, and that's correct, the insurance company doesn't decide the law. What we were saying is for amending the complaint, the number 1 rule is what's the prejudice? And because here, they didn't want to settle, and we had so many months left on the statute of limitations, why couldn't we just amend it? Because now what we have to do is we had to start a
Because
second
this isn't about amending a complaint, it's about a pre-complaint requirement. And you can't satisfy a pre-complaint requirement after the complaint has been filed.
There are cases that say that is allowed.
Okay, do you have another?
No, thank you.
All right, thank you.
Good afternoon. My name is Lauren Donnelly, and I represent the respondents in this case. Public authorities law requires a pre-suit demand and a 30-day waiting period before commencing litigation. It is a condition precedent to suit. It is not discretionary. It is not optional. It is required.
How would amending the complaint fix that?
The amendment of the complaint.
Would it cure that,
It
counsel?
would not cure it. The reason is because the demand must be made prior to the commencement of the suit. The suit was commenced in January of 2024. The demand was made in February. That's after the litigation started. So if you amend the complaint is based on falsities. And you can't get around an amendment on this. It's a condition precedent. They have to establish that they complied with the law and presented the demand, waited the 30 days, and then commenced suit. So an amendment wouldn't cure it. The court did not abuse its discretion. It proceeded with compelling the plaintiff to do what is required under the statute. Unless there's any questions, I'll rest of my brief.
Thank you. Nation Star Mortgage versus Vassie. You may proceed.
Good afternoon, Your Honors. May it please the court, Ronald P. Lebeck for plaintiff respondent in this foreclosure action. Your Honors, the lower court properly granted the respondent a final judgment of foreclosure and sale, confirming the referee's report of the amount due to respondent.
Wasn't the respondent no longer the owner of the property?
The appellant is no longer the owner of the property. I represent the respondent bank.
Sorry. I was thinking of the defendant in the underlying action. The defendant was no longer the owner of the property, right?
That's correct,
And
Your Honor.
when that occurs, there's no basis for a foreclosure judgment, right?
Correct. He no longer has standing to challenge the foreclosure judgment due to his transfer of the property. Appellant argues...
Well, but the bank no longer has standing to seek a foreclosure judgment against him if he doesn't own the property.
No, the bank continues to have standing to proceed with the foreclosure action against the party. I see my time's almost up.
Keep on.
Against the party who has taken over his interest pursuant to CPLR 1015.
But that person wasn't named in the papers, right?
It doesn't need to be named in the papers. If you obtain your interest in a property subsequent to the commencement of a foreclosure action and a filing of a lis pendens in an action, you're subject to all the proceedings in an action as if you were a party.
So you don't need to be named, they don't need to put, you don't need to add the LLC as a party defendant?
No, we do not.
Couple questions. Justice McMahon said that there should be a tolling of interest for a period of time in an early order in this case. Is that order, has it been superseded by the order that you've appealed?
No, it
That
has
the
not.
Appellant is repealed from.
I would love to argue that, Your Honor, but it has not. That order told interest for approximately 3.5 years and additional fees. The current order, appellant requested an additional tolling of interest beyond that, which the court denied, and I believe properly.
Another question, if you have a deficiency judgment, say that you sell the property and it doesn't cover the loan amount outstanding, who do you go after?
Well, in this case, we still could go after Mr. Vassi. He still remains a party to this action.
I mean, this LLC may have zero assets except for the property, right? I mean, it sounds like maybe that's what's going on here. So
Yeah,
if that's the
I
case,
would be
then you would go after Mr. Vassi. And if that's the case, then how can he not have standing?
Well, I think the deficiency judgment really goes towards the damages against Mr. Vassi, and it's very similar to even a defaulting defendant is entitled to challenge the damages in an action. He's not allowed to challenge the substantive arguments in the underlying the action. So I would say Mr. Vassi still has standing to challenge the amount due, that we claimed, or that I think we proved was due in this motion. He had standing to object to that.
So he has standing, it seems to me you're conflating the issue of standing and default, right? Because I agree with you that even when someone defaults, they still can be heard on the issue of damages, which is in essence what we're talking about here, right? And so what case stands for the proposition that you have standing for one purpose but not the other? That I don't understand, right? Because if the bank can still reach this defendant because it doesn't matter that he sold his interest, as you say, and there can be a deficiency judgment if on foreclosure you don't recoup your entire amount due, then I don't understand how he doesn't have standing.
Well, initially, to answer your question, I don't think there is a case that separates standing for individual purposes. However, there is a lot of case law that says once you've transferred your interest in the property, you lack standing to challenge a judgment of foreclosure and sale. That doesn't mean, similar to a defaulting defendant, that you can't challenge the amount due. It was my point. But I think the case law is clear and cited in my brief that the defaulting defendant lacks standing to challenge the judgment. I would also add that his challenge is to service of the RPAPL 1304 notice, which my client has established through proof of standard offer.
Yes, say we don't agree with you. I mean, just for argument's sake, I'm not saying we do or we don't, but if that's the case, then if he still has standing to dispute damages or the deficiency judgment, would he have standing to raise the 1304 argument?
I would say no. That goes towards the judgment, and he lacks standing to challenge the judgment.
But it is a condition precedent to foreclosure cases that 1304 notices be properly served on the parties necessary to be served. So that issue just gets waived. I can see how the LLC might not have, as a stranger to the note, the LLC may not have standing to challenge the 1304 notices. But what about Mr. Vassy?
I want to just add,
Yeah,
if you
that's
don't
okay.
mind, a friendly adder to
You're in
his
the middle.
question. Is the premise of your argument then that because he defaulted, he can't contest the 1304 issue, but because there can be a judgment against him on deficiency, he still can litigate that issue?
No, I think my point is more going.
I'm trying to send you a lifeline here.
I've got confused now.
This is a very interesting case for what is normally
He
not an
can't,
interesting
he can't
subject
challenge
matter.
the 1304 notice because he doesn't own the property.
Right.
That's really our argument. And the statute clearly says it should be the owner that challenges the property. And again, if you are, for the sake of argument, you are correct, again, I would reiterate that we've got ample evidence that the statute was complied with.
There has a question.
So I had a question. It's not only the deficiency judgment that he can challenge. Can't he challenge also any payments under the note?
Yeah, he can challenge the amount due pursuant to the referee's report, and he had the opportunity to do it in the lower court in his opposition to our motion for judgment, but he did not.
But since he has the opportunity to challenge the note, wouldn't he also have the competent right to challenge anything regarding that? Wouldn't that be also a 1304 defense?
I don't know that I would take that next step, Your Honor.
Thank you.
Okay. Thank you so much.
Thank you, Your Honors.
All right. Let me make sure I'm on the right, okay. Prairie Gold Solar versus AGCS Marine Insurance.
Good afternoon, Your Honors. Tom Mulaney for Appellant Prairie Gold Solar. The issue here at this juncture is simple. It is whether it was proper for Supreme Court to refuse to consider the sworn testimony of Prairie Gold Solar's two corporate representatives and therefore not permit their evidence of what they intended to be to appear in the applicable insurance policy to go to a jury.
Didn't one of their own one of the defendant's own witnesses perceived that your clients believed that the hurricane named wind storms were covered?
Mr. Hennessy, was he one of the?
Yes,
Thank
yes.
you. I couldn't remember the
Yes,
name.
respondents' witnesses, but not only did Supreme Court overlook my witnesses, she overlooked Mr. Hennessy, who said it's plainly covered. I mean, if the standard rule that an unambiguous contract is going to be enforced by its four corners is followed here, the case is over. I mean, I get summary judgment. Reformation presents
Which was the court's initial decision.
which was the court's initial decision. And getting into the legalese, I mean, the second decision from Supreme Court leaves out a lot of things that were in the first decision, and I'm not sure why that happened, but I mean, that it is evidence. Even if Supreme Court doesn't believe Mr. Hennessy, Mr. Batchelor, Mr. Callahan, that is for the jury to decide. I mean, that rule is as old as this building. I mean, so the existence of that testimony means that appellant should win this appeal. And, you know, I only regret that I maybe wasn't as clear about that, and I got into the weeds of some more legalese in the briefing below. There are additional facts that were overlooked or just gotten wrong that require us to get to a trial. That means summary judgment's not appropriate for a reformation, and that is this $15,000 additional premium. We paid it. I mean, the premium went up $15,000. Now, there's no evidence what that was for or not for. Is it just a coincidence that it happened to be the same amount that per se, as Ms. Dower said, we'd need to pay? Maybe, but they certainly don't have any evidence. They haven't presented any evidence of what it was for. Zero. Other things that were overlooked, not just Mr. Hennessy's, there is documentary evidence that backs up Mr. Callahan's testimony, Mr. Batchelor. Mr. Callahan performed this hurricane analysis just before the 2016-2017 policy, trying to determine all these things. Before he testified, we would never, you know, in Puerto Rico, never have a policy that didn't cover hurricanes. Mr. Batchelor has emails saying, I love it that we're buying a hurricane policy as a hurricane is rolling in for the previous year. And then for the 2016-2017 year, when Hurricane Irma was coming, a predecessor to Hurricane Maria, he called the broker to confirm we've got hurricane coverage, meaning he thinks that they have coverage. That eliminates the possibility that there could be summary judgment on reformation.
And the policy language says it.
But the policy language is absolutely unambiguous according to per se's corporate representative. If they don't exclude it somewhere, it's in. It's not excluded. It's in. The other thing that was overlooked was Ms. Dower's testimony from per se, who she testifies, yeah, they clearly thought they had it when it came in. It cannot be a mutual mistake if they think they had the coverage when it came in. I see Justice Gesmer might be a little skeptical, so I'm watching this. Okay, I'm waiting for a question. I'm ready.
Well, that testimony on her part seems to me to preclude summary judgment here.
Well, I think it precludes summary judgment, and I understand there's going to be contradictory testimony, and I understand that Ms. Dower may testify, you know, in a way that is not just in response to my questions, but that's for a jury. I mean, this is not, and none of it is mentioned, by the way. I mean, what's really crucial here is that these are pieces of evidence that create an issue of material fact that were just not considered, and they had to have been considered, and they have to go to the jury. And in a reformation case, the one piece of evidence that is overlooked, and we all seem to forget about, strangely enough, is the policy itself, which I think Your Honor may have been getting to. It is presumed that that is the best evidence of what the party's intentions were. So in order to get summary judgment on reformation, you have to actually ignore the policy, which is a contrary piece of evidence. And I think that's improper. I don't think there's much, it shouldn't be the law. There isn't much case law on that, because the reformation claim obviously means somebody thinks there was a mistake. But by definition, that contract is a piece of evidence in our favor. in this case. I'm happy to entertain more questions, or,
Reserve your time for,
well, I may reserve my time because Ms. Hoffman's a wonderful lawyer, and I expect I'm going to have to be sharp.
all right. Let me set the clock for you. Hold on 1 minute. Floor is yours.
Good afternoon. May it please the court. My name is Jennifer Hoffman on behalf of Respondent RSG Underwriting. Despite counsel's attempts and what it sounds like the concerns of the court, there are no fact issues. This is a straightforward case of reformation. Reformation is appropriate relief when there is a mutual mistake, and that's where the parties
How have you established a mutual mistake here?
Okay, so what is the
Because
mistake?
I don't see it on this record at all.
Okay, so if you look, we agree, looking at that 2016-2017 policy, there is no exclusion for natural catastrophe or hurricane or named windstorm. That is the mistake. If you look.
No, wait, but
Yeah, there was
if that's on its face, that there's no exclusion for that, why do we go beyond that?
Because we argue that it was a mutual mistake. And when there's a mutual mistake for reformation, you look at extrinsic
What
evidence.
evidence is there of a mutual mistake?
Okay. So if you look at the evidence, first you want to look at when this facility was brought online to this when this facility was brought onto the policy in 2015, they added it.
So we're not looking at the original policy.
Correct. You look at the underwriting history. Now once you're in reformation and you're looking at mutual mistake, and this is like Ribicoff. This was a 2003 case from the first department, and Ribicoff had the exact same facts. There was an insurance policy issued without an exclusion, and the broker testified, oh, the client, my insured, never intended to purchase this policy with this coverage, and the policy mistakenly did not have the exclusion. This case is even stronger than Ribicoff, though, because you have testimony from the insured and the broker. So the testimony from the insured, if you look at that first policy where they bring productor onto the policy, it specifically says natural catastrophe limits and corresponding additional premium have been declined. Prairie Gold then asked its broker, yes, can you confirm that I have weather coverage for weather-related disasters, including hurricanes? The broker, their agent, told them you did not elect to purchase that coverage. That's at record 331.
What about Mr. Hennessy's testimony that was alluded to earlier?
So the testimony, that's looking at the four corners of the 2016-2017 policy. We agree, but that's where the mistake is. And that's when you argue for reformation and mutual
Didn't
mistake.
he express also a division within, per se, that between two different divisions, one was the underwriting group and one was the claims group, that, they had differing interpretations?
They did have differing interpretations, but we think that's irrelevant because they are all still looking at the 2016-2017 policy.
How is that irrelevant? If your own divisions aren't on the same page as to what it means, how does a person buying insurance get there?
Because that's looking at the policy, and with reformation, you look at.
Oh, and we shouldn't look at I thought that was, to me, that was like the most just extraordinary statement. Oh, you shouldn't look at the policy
Not with-
language to understand what you're getting.
With all due respect, not when it comes to reformation. In Ribicoff, they didn't look at the four corners of the policy. They acknowledged that there was an exclusion that was missing, and that was because of a mutual mistake, where both parties, where the insured.
Except you don't have that here. You don't have both parties
Yes.
saying there's a mutual mistake
We
here.
do, Your Honor. We do, Your Honor. If you look at their evidence, so Batchelor and Callahan designated the task of buying insurance, communicating with the broker to Susie Simcoe and Luke Nelson. Those are the two witnesses that testified, undisputed, that they did not purchase this coverage, they declined it, they were holding off.
They declined the additional coverage of what was categorized as Nat Cat because they perceived, according to their testimony, they perceived that to be for smaller storms, and since the policy they had, the language they were looking at covered them for hurricanes and named storms, they did not see the need for that.
We disagree, Your Honor. At record 456, you see Susan Simcoe from Prairie Gold says, we are trying to determine when we need Nat Cat covered. She uses that phrase, Nat
Right.
Cat covered,
This is the employee
of Prairie Gold.
of Prairie Gold.
Correct.
She's not one of the principals who's making the driving decision about this.
But those principals designated her and say on the record that they were the ones who had the day-to-day involvement. that they had no involvement in purchasing insurance, that they were not the ones dealing with and talking with Willis. And that's the other thing. Willis is their agent. Willis bound this coverage, so the communication with Willis and per se, the broker binds Prairie Gold. So the agent themselves said, bind this cover without the Nat Cat, without hurricane coverage. They declined it. The idea of
You
this,
said Nat Cat, not hurricane coverage.
they use these terms.
No. But that is the point, that there is an issue of fact about that. You say that Nat Cat and hurricane are the same thing. And the other side is saying, no, we thought they were two different things. And so that, ma'am, equals a quintessential issue of fact that has to go to the jury.
Your Honor, Prairie Gold asked its broker, I don't understand these acronyms, can you explain it? And Willis did. They said Nat Cat means natural catastrophe. They said named wind, and NWS means named windstorm.
And a named winter storm is not a hurricane?
A named windstorm is a hurricane.
Okay, so then there is a difference between a named winter storm, a hurricane, and a national and a literal
Nat Cat.
Nat Cat.
But all the witnesses, Prairie Gold witnesses, use this term. The investor document that Prairie Gold sent to its investors specifically uses the phrase Nat Cat, natural catastrophe, in the context of purchasing hurricane coverage. Those witnesses, now while Mr. Batchelor and Callahan conveniently are trying to say, well, we didn't know what it meant. This is alphabet soup. You have all these acronyms. The fact remains is that Prairie Gold asked its broker, explain these acronyms. They did. The internal emails among Prairie Gold employees to Mr. Batchelor and Callahan have a subject line that says hurricane coverage. And then within those emails, they're talking about hurricane coverage, named windstorm, and Ms. Susan Simcoe herself says we need to determine when we need to have this Nat Cat coverage. And then in the next email, she says at 4:56.
But counsel, isn't it clear that the named windstorms are hurricanes?
Yes,
And that those were not excluded?
correct. We agree.
And so therefore, the Nat Cat covered something else, that is smaller storms which lack names, nameless storms.
No, Your Honor, we disagree. The evidence in the record is that natural catastrophe was for named windstorm and earthquake.
Why would you have, if that makes no sense, if they already had a policy covering named windstorms, why would they need another category of insurance to also cover named windstorms?
In this case, Your Honor.
Or where in the record does it say that Nat Cat covers named windstorms?
So the emails, so if you look at the string of emails, there is 330.
So we can't look at a policy. So you buy an insurance policy to cover a huge business like this, and you've got to download every single email you've had with your broker to figure out what you're covered for?
No, Your Honor, I would say in the record, there is a quote where they specifically asked, can we get this coverage quoted? That's at 339.
Counsel, I know you want to keep on reading the record to us, but we've gone through this record, I assure you, okay? What I want to know is it coincidental that the increased premium to these, to your adversaries here happen to match the exact number you guys quoted for the Nat Cat insurance which they paid?
Yes,
Is
Your
that
Honor.
coincidental?
Yes, because insurance premiums go up each year, and they had a prior loss. And so they were told that this is going to your insurance, you had a prior loss.
By the exact 15,000 that okay.
It is, and Your Honor, we have the broker who acknowledges that the premium increase was because of the prior loss. So counsel is incorrect when he says that there is nothing in the evidence that demonstrates that there is a connection between, there is no connection between the increased premium and the additional Nat Cat coverage. What you have is, I was trying to find it for Your Honor. Oh, it's at 657 and 1030. 1030 is the broker where they acknowledge that there was a prior loss, and if you follow the thread of the email, that is why they had a prior loss and they extended the coverage for 90 days because they were trying to shop it around. And their broker said, this is the best coverage I can get you because of this prior loss.
I believe my colleague has a question.
We've heard from my colleagues about the ambiguous testimony, reading the record back and forth, but isn't the definition, strike that, the Reformation standard by clear and convincing evidence, given all this ambiguity, given all this quagmire, and we're digesting it now, laypersons who would see this, how can you say this is clear and convincing?
Because for two reasons. One, when you look at what the witnesses are saying, they're saying, I look at this 2016, 2017 policy, I thought I had this coverage. We agree, but that's where the mistake lies. There is no exclusion. There should have been exclusion based on the mutual parties. Second,
Thank you. You had 2 minutes left over, so you now have 3.
Thank you, Your Honor. It is not, I'm going to take issue, Justice Hagler, with the standard on reformation and especially on summary judgment. It's not just that it has to be clear and convincing. It has to be not just overwhelming. There has to be no evidence.
That's what clear and convincing
Contrary.
evidence.
None. Clear and convincing, overwhelming, beyond not just a
I'm agreeing with you.
any doubt. Yes, I got it, Your Honor. And as far as what the increased premium is for, nobody communicated to anybody at Appellant why these respondents increased the premium. What was communicated, allegedly, and of course there's no evidence of that, it's surmise from some third-party emails, was communicated as when my client went out to the marketplace to see what other carriers, what other underwriters might be issuing. The premiums were high. We have no idea what the numbers were. And those premiums might have been very high because of a prior claim. But that doesn't mean that that's why these underwriters increased their premium. It's some of it, maybe, yes. But there's no evidence of it. I mean, nobody from respondents is saying, yes, I made the decision on what the amount of premium was going to be, and we made this decision because of X. There are inferences to be drawn on both sides, and that gets beyond summary judgment.
Well, it would seem to me that if there's a decision made like this to increase premiums because of a payout, that there should be some documentation in the insurance office of that analysis, breaking down what was paid out on another claim, how much that cost. There's got to be some actuarial formula that they come up with for determining how much we're going to add on to your current policy in order to recoup what we've already had to pay you.
That's correct. And I would say also, Your Honor, that
And that's not in this record.
and that's not in this record, and that in a scrivener's error case, there has to be a scrivener. And you would think that there'd be in a record somebody saying, I had this contract endorsement, I was supposed to attach it, and I didn't do it. It was my mistake. Or I meant to put the general exclusion language in, it was in version 1, I sent them version 2 by accident, it's my mistake. There's a mistake. Here, there's no, in fact, they don't have an affidavit from anybody, so arguably they don't have any evidence at all.
And they discover this mistake the day after Hurricane Maria.
The day after, and Ms. Dower, who says we shouldn't rely on the policies as they're written, she wasn't talking about whether under reformation we ought to be going outside of the four corners of a contract to look at extrinsic evidence, whether we should be looking at the extrinsic evidence of a prior policy, which is what they talk about. There's no confusion, by the way, at all about the 2016-2017 policy. They're talking about the underwriting file from a prior policy. But Ms. Dower is saying, well, we like this language to be this way, because if you don't know the vernacular, you don't know the shorthand. You know, maybe you're going to pick the wrong language and we'll deny your claim because we're going to use the language over here under this.
Thank you.
Thank you, Your Honors.
Thank you. People versus Trevon Small. You may proceed.
Good afternoon, Your Honors. Thomas Palumbo with the Legal Aid Society here today on behalf of Mr. Trevon Small. Now, Mr. Small was illegally stopped, searched, and frisked by the police based off of, frankly, incredible testimony from the officers. The officers rely on testimony that is directly contradicted by the body-worn camera footage that's submitted in this case. Now, there are 3 parts of this stop, and I just want to highlight that if at any point the officers exceeded their authority under the DeBoer standard, the evidence in this case should have been suppressed. So, as I mentioned, there's a level 2 stop, that the officers escalate to a level 3 seizure and then a frisk. But I want to start with the level 3 part because I think that's the most egregious situation we have here. The officers have approached Mr. Small, and he has complied with all of their requests to this point. He has shown them his hands. And instead, the officers still grab his wrists.
Counsel, did that come before or after the Supreme Court characterized him not removing his left hand out of his pocket? I watched the video. I didn't really perceive that myself watching the video, but wasn't that what elevated it from a number 2 to a number 3 under DeBoer?
So that's what the prosecution is saying, is that Mr. Small not having his hand out of his pocket right away is what escalates this. But what you can see on the body cam is first, the officers approach Mr. Small. He has his hand in his pocket. This is January 2nd in New York City. It is perfectly innocuous to have your hands in your pockets. Now, there's no sound on this portion of the body cam, but you can clearly see the officer gestures to Mr. Small's hand. Mr. Small says something in response. And as the officer is talking, Mr. Small removes his hands from his pockets and shows them. And even Officer Quisp at the suppression hearing says, I asked him to take his hands out. He asked me why he had to do that. And then I told him that, as Officer Quisp says, I told him the area was dangerous in order to get compliance from him. Officer Quisp never testifies that the area was truly dangerous. He says, in order to get compliance, I told him that. And Mr. Small does comply right away. So at that point—
There's really no lengthy interval of time.
Your Honor, I would recommend just going back to the body cam. If seconds go by, it's a long time. And the only other thing that the officers depend on here to escalate this to a level 3 is something that even the Supreme Court in their hearing decision found incredible. When the officers say, oh, he's turning to run away to a block that is fully behind him, that's actually blocked by a brick barricade, if you look in the body cam footage. And the court in the suppression hearing says, isn't he just turning to look at the other officer? And if you watch the body cam footage, that's exactly what's happened. And the idea that Mr. Small would be getting ready to flee after fully complying with the officers, when he is with a female companion, when he has his hands out and has just said, why do I need to take my hands out? The idea that that raises the police's level of suspicion to reasonable suspicion that a crime has taken place, it's frankly incredible. And at that point is where the officers do what is unquestionably a level 3 seizure. Again,
Now, I suspect that your adversary will get up and say, well, it doesn't start where defense counsel started. The officers see your client cross the street when he notices the police officer. Is that a crime?
No, Your Honor. And in fact, once again, the suppression court judge says, couldn't they have changed their mind? It's perfectly legal to—
Then the other thing that the officer points to, and I suspect we will hear, is that your client hands something to the female that he is walking with, although the officer admits that he cannot discern what it is
That's exactly right.
at all.
And Your Honor—
I mean, he tries to play it looked like something plasticky, but he saw nothing.
Yes.
Right?
And
And there was no drugs recovered.
absolutely, Your Honor.
Right?
And I would highlight that.
And then, because I know where you're going, so
Yes,
let me
Your
help
Honor.
you. So, and then the officer says, but there was no exchange of money, which you would normally see after a hand exchange like this. So he gives her something. He doesn't even tell us what she does with it.
That's correct.
She's not searched, right?
That's correct.
And no drugs are found.
No drugs are recovered from Mr. Small. The officers never even search this other woman. And by the way, we're saying other woman because the officers never even get her pedigree information for this person that they are saying has narcotics on her. And Officer Quisp, I would say, says at first, oh, I saw something plasticky. That's why I think it's narcotics. But when the judge says, well, what did you see? Couldn't it have been money? He says, yes. Could it have been a piece of gun? He says, yes. She says, couldn't it have been anything? He says, yes. So what the officers are asking you to do is say, you need to believe that I knew it was narcotics because it was plasticky, which is a claim that on its own defies logic. But further than that, he can't even say it's a plasticky object because money is not plasticky. A piece of gum is not plasticky. Officer Quisp is basing this argument off of, again, frankly, incredible testimony. And one other thing I do want to highlight is as this escalates, they grab Mr. Small's wrists. The prosecution talks about that Mr. Small pushes the officers back. But once again, police conduct is reviewed at its inception. So what Mr. Small does after the police grab his wrists cannot justify the police grabbing his wrists.
Oh, there was another claim that, that they observed as he moved a shift in weight in this puffy jacket. And I saw the video several times. I saw no shift in weight, and neither did the judge. Am I right?
That's exactly correct, Your Honor. Again, we're talking about a puffer jacket. This is, again, January in New York City. You look at the video, there's no shift in weight. And even assuming, for the sake of argument, that the officer did see some shift in weight, we're talking about a jacket pocket. We're not talking about a waistband bulge here. We're not talking about up a sleeve, which is one of the cases that the prosecution cites too. And the Court of Appeals has consistently found that pocket bulges are inherently less suspicious because it truly could have been anything, and that's the case here. The officers acted beyond their justification.
Thank you. Counsel, you're on.
Good afternoon, Your Honors. May it please the court. Ethan Solomon for the people. The conduct of the officers in this case was justifiable at each step of the encounter.
So at what point do you claim that Mr. Small handing a small object to the woman he was with was an indicia of criminality?
No.
Okay, so at what point was there an indicia of criminality?
Are you're asking just to get to the level 2 for founded suspicion? We wouldn't point to any individual act and
But wait a minute, you have to under DeBoer.
Well, it's the totality of the circumstances, Your Honors. It's the fact
You have
that
to have a series of events that together create the totality of the circumstances.
Right.
What events together create an indicia of criminality to get you to level 2?
the apparently evasive crossing of the street.
I'm sorry, is it illegal to cross the street?
No, Your Honor, but
Okay,
you
so
don't
if
need
somebody
to.
crosses a street and then crosses the street back, having remembered that the person they're going to go visit lives on that side and not on that side, why is that an indicia of criminality?
When you combine that with then seeing the apparent transfer of what appeared to be narcotics.
Which could have been a lifesaver, right? Or a lozenge, which is a very, I mean, a hard candy is a common thing to pass to somebody else on a cold night, right?
It could have been, but
So you've got people crossing the street, which is not illegal, people crossing the street back, which is not illegal, and people handing something which could be a hard candy. Where is the indicia of criminality?
the combination of these events, the fact that
Innocuous things put together don't equal reasonable suspicion, okay? They don't. Not, look, you've got to, crossing the street, we can agree, is not illegal. Looking back at the police officers while you cross the street is not illegal. That does not create a basis for a stop, okay? So the only thing you have in this fact pattern is the passing of something. The problem is your officer admits that it could have been anything.
But as we cite in our brief, Your Honor, this court has held that the officer doesn't need to be able to identify exactly what the object was.
Can I stop you? Logically, if something was handed to the female, wouldn't it be necessary for the police officer to investigate the female to see if there was narcotics rather than going to the other person? If they thought that there was a narcotics transfer, you want to discover the narcotics. So why wouldn't you even frisk or investigate, have a found suspicion of the female rather than Mr. Small?
Well, the events in this stop unfolded fairly quickly, Your Honor.
You have no answer.
Sorry?
So you have no answer.
Well, I'm saying that we don't know whether the police would or would not have gone to the female.
No,
had-
but we
had
know
events
because
not-
it's on tape. You see, that's the problem, right? We have a video cam here.
Right.
They don't even talk to her.
It makes no sense that if the officer thought there was narcotics being transferred, they wouldn't even investigate the person that possessed the narcotics to actually go through with an arrest.
Well, so they make this stop and they approach both people and they see that the defendant has his hand in his pocket and they ask him to take his hand out of his pocket.
And he does.
He doesn't right away.
He
and
does
that's the-
right away. Again, we have the video. And the fact that the officers chose not to put on the sound until it behooved them doesn't help them.
The testimony at the suppression hearing, Your Honor, I believe, is that Officer Quisp asked defendant to remove his hand and defendant didn't. So Officer Quisp asked him a second time, at which point defendant was asking why he had to do so. And that's when Officer Quisp told him that it was a high crime area and that
But
he
that
had
whole
concerns.
sequence took less than 5 seconds.
Yep.
Based on the video. I mean, I read the transcript first and then I watched the video and I was expecting there to be like an interaction between them that might take more than a few seconds. But in fact, what you can see, there's an interaction and then within 5 seconds, at 10 at the outside, he took his hand out of his pocket. So I'm having trouble understanding where this delay came from.
Not even 5 seconds.
We would suggest that in terms of whether it influences the officer's perception of what might be going on with that pocket, that any non-trivial delay, it can
So
be
you're saying if a police officer approaches me and says, take your hand out of your pocket, and I hesitate for 10 seconds, that officer now has a right to physically impose his will on my body. That's what you're saying.
not.
I asked you to take out your hands from your pocket. He didn't do it fast enough for the police officer, so he has a right now to physically intercede, still without any indicia of criminality.
If that were the only thing that had happened, if an officer just walked up to you on the street and said this to you, then of course not, Your Honor. But that's not what happened
It's not
here.
so far from what happened here, counsel. They got out of the car, they approached him. Within seconds, his hand is on the defendant.
They got
Within seconds. And I'm gonna go look at it and count them. Because I know, seconds, it was just seconds.
It is a short period of time, Your Honor. We're not arguing that things happen fast in this encounter.
Pardon the pun, can we shift to the level 3
Yes.
with the bulge in the puffer jacket and there was a shifting of the weight? Because I thought that the trial court made a credibility finding that that did not occur.
Your Honor, I think what the trial court found was that Officer Quisp testified credibly when he said that he observed a shift in weight, but that the trial or the suppression court, given the angle of the body cam footage, admittedly did not itself perceive that
Okay,
shift.
thank you.
All right, so let me ask you one question. Under our case law, is it enough that there be a shift of weight in somebody's pocket that allows an officer to now physically intercede? Or does that shift in weight have to resemble a gun?
I do not think the shift in weight has to resemble a gun.
No, so I could have a walkie-talkie in my pocket, and I move to the right and it shifts, and that gives the officer the right to go in my pocket?
If the rest of the totality of the circumstances
Okay.
creates that
We're gonna go,
situation.
okay.
Thank you, Your Honor.
Your Honors, I'll be brief here. I just want to highlight again to what the prosecution just said about a trivial delay. Not only is this interaction happening within seconds, but Mr. Small is interacting with the officers. He has complied with them to stop already and simply says, why do I have to take my hands out of my pockets? Even Officer Quisp says that's what's happening during this delay, and there is plenty of case law saying that people are allowed to ask the police, why do I need to do this, especially in cases where it is the initial contact. Now, further just to the credibility question in Officer Quisp here, I also want to highlight that you can see both from Officer Quisp's testimony and the body camera footage that he is on Mr. Small's right side. He says that this gun is going to be on the left side. But as you see in the body cam, he puts both of his hands on Mr. Small's right arm and then testifies that he felt a gun on the left side of Mr. Small. Not only that, he testifies that he feels an L shape on the other side of his body while holding his right arm with two hands. Your Honors, this testimony is frankly incredible. There's a level 2 stop, a level 3 stop.
And Officer Connolly didn't testify at this hearing, correct?
That's correct. And Officer Connolly is the person who actually recovered the gun, was not called to testify. So again, there's 3 levels here. We would contend that the police do not meet their level of justification for a level 2 stop, a level 3 seizure, or a frisk. But Your Honors, all you need to find is that they didn't meet their justification at any one of those levels to find that this evidence should be suppressed.
Do you agree that a series of, if the police observe a series of things such as crossing the street and handing an object to another person, each of which is not criminal, that taken together, those innocent events can together constitute criminality?
No, Your Honor, and what I would say here is we have the divorce standard for a reason. So the officers can, if they have a lower level of suspicion, create a lower level of intrusion. But that's not what happened here when the officers are saying he crossed the street and I found that suspicious. He handed a woman he was walking with something that could have been anything, in their own words. I found that suspicious. He had his hand in his pocket in January. I found that suspicious. We can't find a totality of the circumstances proving guilt from 3 innocuous behaviors, and that's why this evidence needs to be suppressed.
Thank you.
Thank you, Your Honor.
Barron's Media versus Shapiro Legal Group.
Good afternoon.
Good afternoon.
Please the court, David Lakowitz of Tartar Krinsky Drogan for the defendant appellant Shapiro Legal Group. The appellant law firm contracted with a marketing vendor known as KMBR. 3 of those partners later advised this law firm that they had decided to terminate their partnership and that they had started a successor firm known as MKB. Thereafter, MKB provided marketing services to the defendant law firm. Plaintiff sued its former partners, alleged that
The plaintiffs allege that this new entity continued to provide marketing services utilizing their same clients, their business model, their confidential information, including their client list, sales scripts, sales processes, business concepts, pricing formulas, pricing terms, and procedures.
That's correct, Your Honor, and we take no issue with any of that. What we are here to talk about today.
So how is it that they are able to get locked out when your clients owed a fiduciary duty to them?
No, but that's the point. My client does not owe any fiduciary duties to them, nor do they allege that.
I'm sorry,
Your Honor is
partners don't owe each other a fiduciary duty?
No, I believe there's a disconnect. We were not a partner. They have a dispute.
No, I understand, but the partners within the partnership.
100% they owe a duty, yes, Your Honor. We don't dispute that at all, and we don't dispute that if the facts are as alleged, perhaps they have a viable claim against their former partners for violating their fiduciary duty.
How about you for aiding and abetting?
That's what we're here to talk about. So when you first...
So if you know about the other entity and you know about the other contract and you now create a new one to do the same thing that the first one is doing, how is that not aiding and abetting?
So before I get into the specific facts, just to, if I could provide an analogy, it would be as if...
No, don't give me an analogy. Answer my question.
So because this complaint needs to contain details pled with particularity about things that my client did
They say that there are 28 paragraphs, this is the plaintiff says, there are 28 paragraphs that do go to that second element of aiding and abetting, and that you only quote from 2 of them, and then their brief is replete with quoting of the other 26. So it is a pleading motion. Why aren't those paragraphs sufficient?
Because if you read those paragraphs closely and see the actual allegations, so for instance, they say that my client participated in the vote to dissolve the partnership. There's no allegation that my client had a vote, that they manipulated the vote, that they somehow orchestrated the vote. They say that my client helped form the successor entity. There is not a single allegation as to what or
What
how
about
my
the
client
deviation
did
of
so.
an income stream that was supposed to go to KMBR, but instead went to MKB?
I'm glad Your Honor asked. So there's 2 specific factual allegations in that regard. One concerns a reversed wire. The complaint does not allege that my client reversed that wire. My client made that payment to the original entity. Those partners then reversed the wire and sent it back to us. So if you put yourself in the law firm's shoes, the law firm is told, hey, your marketing vendor is no longer working, it is dissolved. You just sent us a payment, we're gonna send that back to you because that company is dissolved. There is no allegation anywhere in the complaint about anything specific that my client did.
How much discovery have we had?
0. But Your Honor, we're here on a facial.
I know what we're here for.
On a facial.
And what I have in front of me are sufficient allegations that should be fleshed out. And perhaps we revisit this issue in a motion for summary judgment.
But if you look closely at the.
We have looked closely. Just because we don't agree with you doesn't mean we haven't looked closely.
So, counsel, there are at least 4 areas in the complaint where the plaintiff set forth the substantial assistance. One was diverting payments to KMB. I understand that you argue that it's innocuous, but it's a 3211 motion, so we have to take it as true. Concealing the payment, which is more than just stating that you had to just change it because it was requested. Cutting off KMBR's access to email system, and utilizing KMBR's confidential information. And it's spelled out, as my colleague said, in 28 paragraphs. This is a pleading requirement, and we must, on a 3211 motion, we must accept that as true. And why shouldn't we do that in this case?
I of course agree, we need to accept the allegations as true. I'm not arguing that those allegations are innocuous allegations. I'm pointing out that the complaint says that it was the other 3 partners that reversed the wire. My client did
But
not.
that's not the only allegation here, counsel.
You concealed the payment. The argument's that you actually concealed the payment. It was your actions, not the partners.
Let's talk about that briefly. That all comes about in the context of the special proceeding to enforce the subpoena. And what they are arguing is that my predecessor lawyer misrepresented certain documentation in connection with the production in response to the subpoena. They have recourse. That's a discovery dispute like any other. All they had to do was go back to the trial court.
So, counsel, I thought it was much more than that. I think you said there was no net proceeds, and it turned out to be millions of dollars with net proceeds, which would then garner the, I think you changed the percentage, it was 50 then to 66. And as a result of that, you concealed it. Therefore, that would be part of the aiding and abetting.
Just to answer the question.
You can answer the question.
The no net proceeds allegation is that my predecessor counsel made that representation in a meet and confer in connection with the dispute over the scope of the subpoena. And there is no law in this state that we are aware of that supports the proposition that the position taken by counsel in connection with responding to a subpoena.
Except that counsel responds to a subpoena and provides discovery given to it by its client. We will hear you on rebuttal.
May it please the court, my name is Justin Bonanno of Haynes and Boone, counsel for respondent, plaintiff Barron's Media. Your Honors, I think you're getting this. As Judge Cohen got this absolutely right. This is a pre-answer motion to dismiss. It's a very difficult standard to overcome. All allegations are in the complaint are to be deemed true, and all favorable inferences are to be given to the non-moving party, which is our client. There's over 115 paragraphs of detailed factual allegations many of which are supported by documentary evidence, including emails, even before the dissolution of KMBR happened. And we also have documentation to show and allegations that Mr. Shapiro, his company, not only had actual knowledge that this was happening. There are explicit allegations in there that he was told and actually conceded at a deposition that he knew that this was happening before they actually dissolved the company. There are, as Your Honor mentioned, there's over 28 allegations, 40 allegations about substantial assistance, both before, during, and after the dissolution occurred. We have gotten no discovery in this case. The only discovery we've gotten so far is in the related action pending in Florida, where our client is suing his former partners for breach of fiduciary duty. This case has actually been stayed for 2 years until that case plays out, because Judge Cohen wants to wait and see if there's actually a liability finding. And then we get this motion to dismiss that is trying to twist the allegations and that the reversal of this $140-something thousand payment had nothing to do with the client. Well, we need discovery on that, but the discovery we do have actually shows that he was involved, and we actually allege it. And we allege that with respect to every single allegation. If Your Honors have any questions, I think this is a very well-pled complaint, detailed more so than usual, and that Judge Cohen got it correct.
Thank you.
Thank you.
I realize, of course, I'm swimming upstream, so I will be brief. There are a couple of things that counsel said that need to be corrected, one of which is not relevant for present purposes, but the notion—
You got 1 minute, so talk fast.
that we haven't exchanged discovery is false. Mr. Bonanno himself took my client's deposition in this case. The case was stayed after my client produced all of its documents and before they did so. But more importantly, I understand when you look at this complaint, it's chapter and verse, and there's photographs of emails. But if you parse the allegations as to the law firm, not with respect to what these partners may or may not have done to Barron's, there is not a single allegation of substantial assistance that my client knew that there was a fiduciary duty that was breached or that they participated in that. My client was told that its vendor had dissolved.
You represent a client that has a contract with one party, that party's being squeezed out, creating a new entity, and you don't know that there might be a problem here. Thank you.
Thank you, Your Honor.
Huh? Yeah. Yaqual versus Hudson Canal. How do you say the name?
Well, I'll defer to my colleague, but I think it's
How do you
Yagual.
say your client's name? Jaguar? Jaguar? Okay, thank you. You may proceed.
Thank you, Your Honor. May it please the court, Sim Shapiro from the law firm of Strakowski, Drachman, and Shapiro on behalf of defendants, appellants, Express and Hudson. I want to particularly focus on that video, which I know that Your Honors have reviewed. This is sufficient to raise an issue of fact at the very least. Well, I do note my client moved for summary judgment.
Nobody authenticated the video. So we don't know if after Mr. Yagual was lying on the ground, somebody else came over, set up the ladder and left him lying there and then took the video. So how can we, I don't understand why we should give any credence to the video when it's unauthenticated. And we can't.
And even the plaintiff says that doesn't look like the ladder because the ladder I fell off had the name of the company on it.
Okay, so let me answer those questions. It is authenticated. It's authenticated by the
what?
plaintiff himself.
By
He's
who?
saying that's me.
No,
That's
he
me.
Yes,
he doesn't,
and
but
that's-
he says he can't identify anything else in the video besides himself. He was passed out at that point. So I don't understand how his saying, identifying himself in the video authenticates the video. All it means is that somebody came
He
along.
recognizes himself, that's it. That does it, that, you need more than that.
It doesn't, nobody came along and said, I took the video, this is what happened, this is an accurate representation of what happened during this time. That's what authentication is, not, hey, I recognize I'm in that picture.
Okay, so first of all, he was conscious. His testimony at his deposition, well, he did not lose consciousness, so he was not passed out. Beyond that, it is sufficient for a plaintiff, the fact that he's saying that's me, That's sufficient to raise an
That
issue
is
of
not
fact.
sufficient to authenticate this tape when he doesn't identify the ladder. He doesn't know how that ladder ended up propped up because he says he heard it fall. So no, you cannot get that video in through the plaintiff. You want that video in? You should have gotten the person who made the video or someone from the defendant's side to authenticate it.
Your Honor, first of all, he does authenticate it. Beyond saying that to himself, he also says that the ladder is in the same location as the ladder he was on, even though he doesn't necessarily recognize that as the ladder he fell from.
No, more than that, he said it was not the ladder he fell from.
He said, I don't know.
He said that the ladder he fell from had the name of his company on it, which that ladder did not.
What he said, well, that's not so easy to tell, but he said he didn't know. But even assuming that's the case,
That he didn't know
identifies
what?
that it's
That he didn't know whether it
he
was
didn't
the
know if it was
ladder
or
because he
not.
didn't recognize it.
Correct.
So that means he can't authenticate the photograph.
No, he can because
All right, we're not gonna go in circles. You can keep on saying what you're saying. I'm telling you.
Your Honor, I appreciate the court's position, but I feel compelled to respond.
Can
which
you
is-
make an argument even that we should decide in your favor, even if we do not accept that the video is relevant and authenticated?
I certainly can. If I just may, though, respond quickly to that other question, which is not only did he identified it as the same location where the ladder he was in, and he identified himself as being in the same location.
Counsel,
To answer your
let me
question-
stop you. I actually have the transcript on page 97. Let me read it to you, and I'll make it clear. We don't have to go around the circles. Page 97, line 9, question. And this is to the plaintiff. And you're unsure if this was the ladder that you were using at the time of your accident because this ladder is standing upright and not on the ground. Is that correct? And the answer is yes, because the ladder I was using had the letters berries, and it doesn't show it here. And also probably a lot of people arrived, and they're probably putting it aside or probably putting up this ladder. So he clearly testified this was not the ladder because people came later. We know this was at least 15 minutes later. We know EMT people were there. He's being treated. So it makes sense that if you have a ladder on the floor and EMS is coming, you need to move the ladder in order to treat the plaintiff. And that's what the plaintiff said. The plaintiff said clearly that this was not the ladder that he fell on because it said berries. It had the label berries on it, and it did not have it, and it was a different color. So there's no doubt that this video, according to him, was not authenticated.
I'm making a different point. What I'm focusing is on page 99 of the transcript and page 291 of the record, where he says the ladder is in the same area that the ladder he was from. So that's really the issue is, could he?
If it's not the same ladder?
Because if it's in the same
Counsel,
area.
I really suggest, and this is, I'll even give you an extra minute because you have wasted all your argument time on this issue. You said you had another argument.
do.
I would love to hear it.
Okay. So, Your Honor, the other argument is there's testimony from Shulam Adler, who went shortly thereafter, and that they had left, and inspected the ladder from which he was told that the plaintiff fell, and he saw no defect in it at all.
Told by whom?
By the workers who were there.
That sounds like hearsay and double hearsay. But I'll hear you on rebuttal.
Thank you.
May it please the court, Michael Cassell for plaintiff respondent, Mr. Yagwal. So just to make this, break this down. So we have a situation where my client testified the ladder moved and he fell. That's a prima facie entitlement under 240.
And before that, he also said that he complained about the ladder because the ladder didn't have rubber footings, correct?
Yes, correct.
Okay.
So the only evidence they have is.
Can I just add a coda to that? And they required him to use it. Is that correct?
Well, they require him to use it because the realities of the work site are you'll lose your job if you don't use it, of course.
That's the complete testimony.
So the only evidence they have is Adler, which is hearsay. I'll address that in a second, and the video. The video is not authenticated, but I'll take it a step further. I'll even assume that the video shows the conditions 15, 20 minutes after the accident. All it shows is a standing ladder. We have Wazaletsky, we have Kebby, KB, another case from this court that have providently held, okay, so what? You have someone with a ladder standing. Doesn't defeat my client's entitlement to summary judgment as to this issue. So that's our position as far as the other thing. As far as Adler, at best he testified that maybe if it was the same ladder, the ladder he looked at didn't have a defect. We cite a bevy of cases that hold that a claim of a lack of defect isn't sufficient to raise an issue of fact.
Counsel,
And our cases have said that repeatedly in this department, that you don't have to have a defective ladder for a 240 sub 1 case. All you need to have is a fall from a ladder that the defendants did not provide proper security for, right?
Ladder must remain steady and upright, otherwise the plaintiff's entitled to summary judgment.
so counsel, also Mr. Adler did not inspect the bottom, the feet of the ladder, so did not know whether a part of the rubber was worn or missing. Is that correct?
That is correct. Thank you. Thank you for your time.
Thank you. Okay. You have 1 minute.
I'll quote my colleague who was here on the case before me as swimming upstream. Nevertheless, I'll give him proper attribution. Nevertheless, I do think the issue isn't, respectfully, the court is focused on, oh, is this the ladder, is it not the ladder? That's not what our argument is. Our argument is from that location, and he's saying, that's where I fell from, and I've quoted you the testimony, to the location where he landed up. It's not possible, looking at that video, for him to have wound up over that board. So the issue isn't, oh, the ladder or not the ladder. And I appreciate the court focusing on that. I appreciate that that's typically the way a 240 case is looked at.
So counsel,
That's not what I'm talking about
so
here.
let me address that. So how far was the ladder from the plaintiff? Did anyone measure the area and see if you can fall a certain distance? Is there an engineering expert that would support the argument that you can't fall 2 feet, 3 feet, or 4 feet? I read that argument, but I wasn't impressed because I don't know any specifics. There's no specifics, and that was a hearsay statement in the video itself.
Even if you just look at the room, even if you look at that big board in the middle, that he would have had a good, he fell backwards, that was his testimony. Again, I'm using it on the plaintiff's testimony. The plaintiff said, I believe, I forget, I think it was Judge Moulton asked the question, is there any other testimony? The testimony from the plaintiff himself saying, I fell backward. He would have had to fall backward over that big board in the room to be able to wind up in the location.
How do we know the board was there at that point in time? That's the whole point.
But
All right. Thank you.
Thank you.
People v. Stephen Hernandez.
No, that's submitted.
Yes, it is. It's that I'm looking at my old sheet. Castillo versus Big Van. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the court. My name is Nicholas Tam from Schaub, Amity, Citron, and Spratt, representing the defendant appellants. The motion court's decision should be reversed for 4 reasons. First, the expert established that the symptoms in the emergency department were inconsistent with an ovarian torsion, and testing was not indicated. Secondly,
When you're talking about the expert, your expert assumes that the child had the pain for 3 to 5 days, but in your brief, you acknowledge that there's a discrepancy in the record about whether the child had pain for a day, 3 days, 5 days, or 7 days. So how can we give weight to your expert's opinion when he decided that the 3 to 5 days was correct and that the 1 day or 7 days were wrong? Why isn't that in itself a question of fact that would require us to go forward, allow discovery to go forward in this case?
Well, Dr. Diaz-Martin, the defendant's expert, acknowledges that there were a report of 5 days of pain before the triage nurse. The adolescent told her that it was 3 days. Then a testimony, it also says the plaintiff said 1 week and the plaintiff's mother said 1 day.
Right, so and for some reason, your expert decided it was not 1 day or 7 days, but it was 3 to 5. And that was the essential element of that affidavit. So why isn't that a question of fact that he ignored and that we should not?
Especially here, where we have a mother who does not speak English. And I have to tell you, being a resident of the Bronx, in a county that has, I don't know, almost 55% Latinos, how a Bronx hospital can even suggest that they are incapable of providing proper interpreter services for someone who is receiving medical care for a child, explain that to me, because your doctor makes his conclusions knowing that the mother was unable to communicate and that the hospital did nothing to bring an interpreter by her side.
Let me just add to that, that
Yes.
the intake nurse, in fact, stated that the mother's preferred spoken language when discussing healthcare was Spanish. But still, the hospital did nothing.
So this is discussed in Dr. Diaz-Martin's affidavit by differentiating and making a distinction between subjective pain complaints.
No, that doesn't explain the lack of an interpreter.
And as I said, when you asked me for just 3 minutes, I knew you were gonna need more, so you just keep talking. Go ahead.
So the subjective complaints that the child made were differentiated by the expert.
Now, let's talk about the subjective complaints that the child made, because here, I mean, this was like a layering of insult upon insult upon insult. We have a child who comes in with a mother who can't speak English, tells you, I prefer to speak in Spanish, in a Bronx hospital where I can tell you on the emergency floor alone, you easily had to have at least 20 people who could have translated for her, but nobody is called. So as a result of that, the hospital and the doctors do not get the proper history. And if they had gotten the proper history and known that this child, when she becomes anxious, suffers from selective mutism, it might have explained why the child was not saying, I'm in a lot of pain. So the levels of breakdowns here are multiple. So it's not just, oh, the kid wasn't really complaining. We know why the kid wasn't complaining. But this mother and this daughter never got a shot at proper treatment because nobody took a proper history, because nobody cared that this Latina woman could not understand English.
So the hospital accepts that point for the purposes of this argument. We'll rest on a brief on the liability issue and move on to causation, unless the court wants to hear the position on liability and the other lack of tenderness, rebound, guarding, and persistent pain. So I'll move on to causation. Even accepting a departure, which we do not concede, there's a lack of causation because Dr. Diaz-Martin explains that an ovary that is infarcted becomes necrosed and dies within 7 hours. That opinion...
Isn't that also,
Except that it
so
doesn't-
that would be related to the question of when the pain began too, wouldn't it? I mean...
Even, yes?
Or does the infarct happen in a way that does not cause pain to the patient? I thought that because we don't know when the pain began, that raises an issue of fact about causation.
So even accepting the most generous reading, it's 1 day, 24 hours.
Can I stop you? Because
Yes.
I think that
I really want him to finish that thought, and then you can ask your question. Please finish that thought.
Will do. So even accepting, so there is testimony that it was either 1 day or 7 days from the child, or 5 days as reported to the triage nurse, or 3 days as reported to Dr. Bickham. Even accepting 1 day, the most generous reading of that. 7 hours is indicated as the time in which the ovary, which is twisted, lack of blood flow, infarcts and gets necrosed, would die. So from a matter of causation, and as the court correctly pointed out, the plaintiff's expert, if you look at their affidavit compared to ours, doesn't explain that the ovary would have been salvageable at that point, given the length of time that the ovary had been potentially causing pain to the adolescent. So
Yeah, but presupposing pain is not necessarily, or maybe there's something in the record that supports your point, but pain doesn't necessarily equate with torsion. I mean, it may, but maybe there's some incipient pain that happens before torsion starts and causes some decrease to blood flow that will eventually cause the ovary to necrose.
So plaintiff does bring that up on appeal, but it's not in the record. It's not explained by the expert themselves, Dr.
Does your
Lucci.
expert explain how, if indeed the pain started 5 days earlier, right? And according to your doctor, your expert, within 7 hours of the pain onset, there would have been torsion, then after 5 days, that I would then assume they would say, then it was already necrotic, right? That if indeed it started 5 days ago, when she presented to the hospital the very first time, it was already necrotic.
It was already necrotic.
Okay, now my next question is, does your expert tell me that if it was necrotic already, that you would expect to have guarding and hardness and distension of that area? Because now you've got a dead organ, right? Wouldn't that cause a hardening of the belly?
So the way she explains it is that from an imaging standpoint, the lack of symptoms.
No, I'm talking about, you're saying if there was an onset 5 days ago, by the time the child got to the hospital, it was already necrotic because it would have torsed already, right? And what my question to you is, do I have a statement in any of the records that says when that happens, if it's already torsed, and if the torsing started 3-4 days ago, by the time you get to the hospital and there's a physical examination of your abdomen, that area, because it is now necrotic, would be hard.
It's still, I'm not sure if that specific statement is made, but there is indication that when there are new symptoms, it causes tenderness. When she went to her pediatrician, was referred to Montefiore for a secondary evaluation due to complaints of increased pain, there were new symptoms. So at that point, when the ovary was found to be
New
badly
symptoms, they were the same symptoms, they had just gotten worse. And I believe my colleague has a
Yes, so
question.
I actually wanted to challenge the record, what you're saying, which would actually create a different scenario. I thought the father testified that the child was normal that day. So it's not so it's even within reason to say that it's within 7 hours because the testimony is so ambiguous from no pain that day to the mother 24 hours to Dr. Bickman saying 3 days and the triage nurse saying 5 days. So there is a situation where we can say that even according to the defendant's expert, there could have been an opportunity to save the ovary.
I think we'd have to look at the plaintiff's expert submission, which is completely silent on that issue.
The record shows that, though. We don't need to see any. We have the expert. If the record shows that there's a possibility that causation could have occurred within the 7 hours, and we have testimony in the record that says that it could have been within 7 hours. So I'm telling you, it comes within the plaintiff's, the defendant's expert. So that would not be factually correct with your expert opinion.
I would just have to point, again, to the plaintiff's expert, and their silence on this issue doesn't create a question of fact because they have to bring that point up.
But you've got the initial burden, of course, to prove absence of causation. So I think that's what all our questions are getting at, is have you proven the absence of causation? I know your expert does say that, but given the contrary evidence, including what Justice Hagler just talked about, the father's testimony, doesn't create an issue of fact.
You'll have time on rebuttal, okay? All right.
Good afternoon. May it please the court. My name is James Bacher from the Law Office of J. Bacher, and I represent Evelyn Castillo, as well as her infant daughter, who we'll refer to today as DC, and Ms. Castillo individually. This case, even if you assume that the defendant or appellant made it past their initial burden, even if you assume that, and we don't, we're not conceding that point, it's a battle of experts. The cases that were cited by counsel in their briefs, which seem to suggest that my expert, Dr. Luriani, is not an adequate expert because he didn't mention that he adheres to a subspecialty dealing with infants is not what the First Department or even the Court of Appeals requires. The first,
All of that goes to the weight, not to the admissibility.
that's exactly the point that I was going to get to.
Right, so that's a good point. What about,
Thank you.
what about causation, counsel? What does your expert say about whether or not the departure was the cause of the child losing her ovary?
Well, it's very interesting that Your Honor brought up the testimony of the father, which is something that, by the way, defendant's expert didn't review. That's not part of her affidavit, Dr. Diaz. And in fact, if you look at his testimony, which is what my doctor relied on, asked when he spoke to the mother that night, and this is on.
Now, we know what the father said, but what conclusion does the doctor draw from that concerning causation?
Sure. Dr. Luriani then, based upon that being within that 24-hour period, says that this was an emergent situation that required them to take additional steps.
Okay, record site, what's the page?
It was.
It's in his affidavit, I presume, but if you have a record.
It is. It's in his affidavit. It would be at the record page 1096, and that's at paragraph 9 within that particular page. And he also refers to what other types of tests should have been done, that none of them were on the prior page, 1095. And he explains and he expands on this, that when you have an infant who comes in with this type of pain, you need to perform certain tests. And let's assume that defendant's expert is correct, that they assumed gastritis. They assumed gastritis because she was eating street meat. They got rid of that in their differential. They literally determined, following an x-ray, which was only done because the mother pushed that something had to be done. The x-ray showed there was no gas, there was no lack of air. This wasn't gastritis. They then said, well, that's what we think it is. Now go home. If you get worse, come back later.
Counsel,
And during that, I'm sorry, during the admission, while she's being triaged and worked up, the child vomits twice.
Twice.
And then defecates on herself.
Correct.
And still no CBC.
Absolutely. Which my doctor says you can start with gastritis, but once you determine that it's not gastritis, well, you don't just give up. And their expert even says 3% of a chance that this could be happening. That means that you don't just give up. Why did they give up? Well, because their surgeon doesn't treat infants. Their gynecologist doesn't treat somebody who's 10 years old. This was a failure from top to bottom, and as a result, my client lost one of her fallopian tubes and an ovary.
So one of their arguments is that the loss of one ovary does not affect her fertility or anything else in her future, so there's no harm, no foul. Do you want to address that?
Well, sure. Well, that's not exactly 100% true, Your Honor.
Gynecologists will tell you, and obstetricians will tell you, if you only have one fallopian tube, you don't have the same odds of successful pregnancy as women who have two.
That's exactly right, Your Honor. And that's not really one of the core issues before us. That will be what a jury gets to hear and why
Counsel, can I stop you? Because you're correct. If you look at paragraph 9 with regard to causation, I just want to read what the expert said, because I think a lot has been said that there was no causation testimony by the expert. On 1096, in the middle of the paragraph, had the additional diagnostic imaging been done at the time, referring to at the time of treatment, that was at Bronx Lebanon Hospital on August 2nd, 2002. It is my opinion, within a reasonable degree of medical certainty, that the left ovary and left fallopian tube could have been saved.
Thank you, Your Honor. And if I can just give me 10 seconds to briefly conclude, just for all of these reasons, we believe that the court's decision below was correct and ask that you affirm.
Thank you. Okay. I'm I'm going to give you 2 minutes for your response.
Sure. So our expert, Dr. Diaz Martin, sorry, I lost it. On page 24 of the record, 24 of the brief, but page 53 to 54, paragraph 18 of the record, discusses the causation issue in depth. She indicates that, quote, additionally, even if DC's torsion had been diagnosed within a few hours of onset, there is no proof that the ovary would have been saved.
And there's no proof that it couldn't have been saved.
Well, she goes on to expand. She says that she would have required surgery anyways to assess, and that a large percentage of torsions that result in surgical removal of the ovary occurs regardless of the time of the onset. That's something that remains unaddressed by the plaintiff's expert. So that's how I would expand upon the causation argument.
But she would need surgery anyway, so it's okay you didn't do it fast enough?
That would be a causation argument, because many times it needs to be removed. And surgery is a given, according to the expert, but the removal of the ovary itself in a large percentage of cases needs to be done just because of the necrosis, the infarct, and the potential further damage that could occur because it's twisted and could...
And that may all well be true. But the issue here is whether this child even had a shot at saving her ovary based on the treatment she received by this doctor and this hospital.
Understood.
That's the issue.
Understood. If there's no further questions, I'll rest on my brief.
Thank you so much, both of you.
Thank you.
And last but certainly not least, Boleg Gowen versus White Plains Kensington.
You stole my line.
Okay.
May it please the court, I'm Annette Hasapidas Law Offices for the plaintiff appellant. In this case, the court respectfully erred in granting summary judgment. The defendants never made out a prima facie case as to notice. Defendants were required to present affirmative evidence. In their motion, defense counsel's affirmation at page 19 said that there was no notice, and at page 22 and 25, they referenced plaintiff's testimony that she had not previously complained about the umbrellas. But what was glaringly omitted was testimony from defendants that there was no notice, and that's because they omitted the transcript of Mr. Alvera, who was the maintenance individual, and the key pages of the record from his testimony are pages 450 to 452, and he conceded notice. He said, on windy days, we have to pull them up, otherwise they can be dangerous.
But was it foreseeable that the umbrella would rise up the way it did, sort of like a helicopter, and then hit somebody? Is that foreseeable?
Yes, given Mr. Alvera's testimony. He testified.
And under our case law, though, does the exact happening of the accident have to be foreseeable, or just that there is a danger?
Yes, that's precisely it. At page 450 to 452, Mr. Alvera testified, in fact, that on windy days, it was very difficult to open up the umbrellas, and you needed 2 people to do it. These are 8-foot wide umbrellas on a second-story patio. He also testified that when it was windy...
It blows up?
Right. Right, he said if it was a windy day, you open it up, you need somebody to help you open it, but that it could be dangerous because it could fly out and fall on the street. So they conceded notice, they just didn't provide that evidence as the movement, and they didn't provide any evidence from defendants in support of their motion as to notice. They provided the testimony of Ms. Watson, but she was not with maintenance, and she didn't provide any testimony as to notice. There was no evidence as to whether there was a specific procedure for installing these umbrellas. They were simply inserted in through the hole and put into a base. There was no testimony that these umbrellas were secured to the base in any way. And there was no monitoring.
The photo that she said, that your client said was the most representative of where she was sitting, it doesn't appear to show any kind of base for the umbrella. You know, sometimes you have these sort of large hockey puck shaped things that are weighty.
Yes.
That hold an umbrella in place, but I didn't see that in that photo.
There wasn't in that photo, and the defendants have argued that that is not necessarily the same umbrella or necessarily proof that the base was absent. But the fact remains is that no one testified that once they were inserted into that base, they were secured to the base. Mr. Oliveira simply said that they were pulled up or they were put in. So whether or not there was a base there is really not relevant because they would still become airborne. It's an 8-foot wide umbrella on a second-story patio. Even if the burden shifted to the plaintiff, Mr. Oliveira's testimony proved certainly that there was notice to the defendant. If anybody had a chance of winning summary judgment on notice, it was the plaintiff here because of Mr. Oliveira's admissions. But in addition, plaintiff opposed summary judgment on res ipsa loquitur, right? There was no dispute here that the defendants were in exclusive control of the instrumentality. This is a residential
Yeah,
facility.
but isn't res ipsa for when you don't know the cause of an accident? Here we know the cause of the accident. There was only one possible cause of the accident, which is the air lifting the umbrella up. So that's not, res ipsa cases arise, and it's not a doctrine, it's an evidentiary ruling, that
Yes.
It arises, you use it, you invoke it when you don't know the cause of instrumentality hurting the person. In this case, you do.
Judge Moulton, I would submit it's a little bit more nuanced. It's whether or not the accident would have occurred without the negligence of another for res ipsa, that the accident would not have occurred had someone not committed negligence. And so in this
Then
case...
then you got a straight negligence case. I don't know, maybe we're fighting about unnecessary semantics.
Again, I'm addressing the theory that we pursued. First of all, there's questions of fact regarding notice. Secondly, we were also opposing on grounds of res ipsa loquitur. They were in full control of the instrumentality. There was no dispute that plaintiff didn't contribute to the accident. And had they properly secured the umbrellas or monitored the patio, because again, you have 8-foot wide umbrellas on a second-story patio, this would not have occurred.
Thank you.
Thank you.
Good afternoon. I'm Lori DePretta for the respondents. First of all, the respondents object to the statement that there was no base under the umbrella table. The photographs in the record were taken 2 years post this incident.
So what did you submit in the record to show us that they existed?
Well, Mr. Oliveira and his supervisor both testified that the umbrellas were placed within an umbrella table with a base underneath.
But you didn't do anything in your motion for summary judgment like attach a picture of this base that would secure it, right?
No, there were
So
no.
we don't know if it was just went through the hole in the table and was sitting there.
And even if it had a base, whether the base was the kind of base that secured the pole. There are some bases that it's just a hole and you stick the flagpole into the hole. And then there are some bases that you can screw into the base so that the pole doesn't come up as it did here.
True.
And we don't have any of that information.
That is true. But here.
And it was your motion, right?
It was, yes.
So without that, how did you meet your burden?
Well, because the testimony of the party, the question here is whether the defendants, as the owners and operators of the premises, maintained the premises in a reasonably safe condition. They testified that when it was windy, which it wasn't on the date of the incident.
Apparently it was.
Well, but not according to the
We have
National Weather Service.
You submitted meteorological reports saying that there was 11-mile winds. Apparently that was enough to lift the umbrella.
But
or at least an issue of fact, counsel. I mean, you've got to admit that because you've got the plaintiff's testimony saying there were gusts of wind, and that's what lifted the umbrella, or that's her supposition.
But here, the maintenance department testified that if it were windy, they would close the umbrella. There was no, based on the evidence of the prevailing weather conditions on that day, there was no reason for them to believe that having the umbrella opened in that position was dangerous or could possibly cause an accident. The plaintiff herself was sitting there and didn't notice anything, and testified that she had been out there many times and had never had any issues with the umbrella tables.
And how does that help you here?
Because
I don't know what the wind was like on those other days that she was sitting at a table out there. So that statement, the fact that she has been out there before and that the elevators didn't, that the umbrellas didn't elevate, is not proof that it didn't happen this time. So we have nothing controverting the plaintiff's testimony about what happened. So why is that not an issue of fact? In light of what your own witness testified to regarding having to close the umbrellas when it was windy because they could lift out of the hole.
But he never said that they ever had. He testified based on common knowledge that in the event of a wind condition, heavy winds, that an umbrella could possibly topple over.
Okay, thank you.
Counsel's right there to prove that they reasonably maintained the premises. There is no evidence that anyone regularly inspected or checked the umbrellas, whether anyone checked for weather advisories. And there was no correlation between the meteorologist's opinions concerning the wind speed and whether or not that would have caused the umbrella to lift up. No one ever offered evidence that 11 miles per hour, gusting up to 22 miles per hour, would not have caused an 8-foot wide umbrella to lift up from a second-story patio. So there's that. Also, the plaintiff testified that she didn't notice whether there were gusts of winds before the accident. That's at page 153 of the record. And finally, at page 452, Mr. Alvero's testimony indicates that this had previously occurred. He says, if I recall, there is just times where it was a very windy day. Immediately we take them up. That blows up, it goes to the street and causes an accident. Just like with anything, when it rains, a windy day, you have to make sure to be safe. So,
Thank you.